Hello and welcome to the Premises Liability webinar series. I'm Sarah Walburn and I'm going to be talking about third-party contractors. I'm an executive partner with the Grand Rapids office. What is a third-party contractor? As stated in my first slide here, a third-party contractor is an entity entering into a verbal or written contract with premises owners to perform particular services such as snow removal companies, which is usually what we see most in these lawsuits. A parking lot owner, for example, or a mall or an apartment owner will hire a snow removal company to remove snow and ice from their parking lots, and then somebody invariably slips and falls and then sues the snow removal company. Or we'll see lawsuits involving landscapers or irrigation companies, roofing contractors. Anybody that enters into a contractor with a building owner is a third-party contractor. Before I get into the case law, let's talk about the general negligence duties and cases. So in Michigan, we have our prima facie negligence claim that requires the plaintiff to prove that the defendant owed a plaintiff a legal duty. They also have to show that the defendant breached that legal duty, that the plaintiff suffered damages, and that the defendant's breach was the proximate cause of the plaintiff's damages. Now, with the third-party contractor issue, we're going to be speaking mostly about duty. These are going to involve cases where there's a contract between the third-party contractor and the building owner. And the plaintiff, who's the person that got hurt, wants to sue the third-party contractor who's not a party to that contract. So we're going to be discussing duty. So does the third-party contractor have a duty to that plaintiff? So first, let's take a look at duty. Duty usually arises out of either a statute, a contractual duty, so the basis between, or there's the contract between the third-party contractor and the building owner, so is there a contractual duty between the third-party contractor and the plaintiff, or there's a common law duty. Our first case is Derbabian versus Mariners Point Association, and that is a 2002 Michigan Court of Appeals case. In that case, that's your typical pedestrian slip and fall in a shopping center parking lot. So the pedestrian, Derbabian, sued the contractor hired by the owner of the shopping mall to remove the snow and ice. So the Court of Appeals took the case up and held that there was no duty to the pedestrian by the snow removal company. The Court of Appeals held that the pedestrian failed to show that the contractor was a possessor of the premises at the time of the fall, or that the contractor had knowledge of the icy condition, or that the contractor was unreasonable in its failure to salt the parking lot following a rain. Therefore, no tort claim arises solely from a third-party contractor's failure to perform its contractual duties. As you can see, we have a 2004 case called Fultz. Fultz is a pretty important case, as well as Loki, which is the next case. So you want to really reference Fultz and Loki in the next two slides here. Fultz is also a pedestrian slip and fall case in an icy parking lot. A lot of these cases end up being slip and falls. So Fultz held that the snow removal service did not breach the duty of care to the pedestrian. So additionally in Fultz, which is a Michigan Supreme Court case, the court held that the contractor can be liable to a third party in tort only if it owed the third party a duty separate and distinct from the defendant's contractual obligations. If no independent duty exists, no tort action based on the contract will lie. This separate and distinct mode of analysis replaced Michigan's prior emphasis on whether a contractor's actions amount to misfeasance or nonfeasance of a contractual obligation. After Fultz, courts were to forego the misfeasance and nonfeasance distinction and instead employ the separate and distinct mode of analysis. So Fultz reaffirmed the principle that if one voluntarily undertakes the performance of an act, having no prior obligation to do so, a duty may arise to perform that act in a non-negligent manner. And here's Loki, which is a 2011 Supreme Court case. In Loki, we have an electrical subcontractor's employee suing a drywall subcontractor, alleging that the drywall employees had stacked a bunch of cement boards against a wall, and the cement boards fell and injured the electrical subcontractor's employee. He's alleging that they were kind of stacked up in an unstable position, causing him to fall. So the issue is whether the drywall subcontractor owed a common law duty to the electrical employee that was not governed by the contents of the contract between the drywall contractor and the general contractor. What the court held, the Michigan Supreme Court held, was the common law or statutory duties of care were not extinguished simply by the performance of the contract. So under the separate and distinct mode of analysis, which was developed in Foltz, which I just talked about, entering into a contract with another pursuant to which one party promises to do something does not alter the fact that there exists a pre-existing obligation or duty to avoid harm when one acts. In other words, Michigan incorporates the voluntary assumption of duty doctrine, a simple idea that is embedded deep within American common law of torts. If one, having assumed to act, does so negligently, then liability exists as to a third party for the failure of the defendant to exercise care and skill in the performance itself. The Hill case, which is also a Michigan Supreme Court case, came out in 2012. This one involved appliance installers placing a dryer in front of an uncapped gas line, causing an explosion. The court held that no new hazard was created when the appliance installers placed that dryer in front of the uncapped gas line. The installers did not have a duty separate and distinct from their contract to install appliances to take action regarding the exposed uncapped gas line. Now, the court really just looked at whether a new hazard was created. I wanna wait until we get to the new case that came out in June of this year and kind of go back to the Hill case. So we're gonna put that case on hold and we'll come back to it in a few minutes. Let's talk briefly about the Bailey case in 2013, which is also a Michigan Supreme Court case. In this case, the Court of Appeals held that the company that employed guards of an apartment complex did not have a duty to protect the guests. So what happened here was an apartment complex hired guards, and the guards did not protect the guests from a criminal activity. But while the guards did not have the duty to protect the apartment guests, the owner of the apartment did have the duty to notify the police if there was any suspicion of criminal activity, something to that effect. So while the guards didn't have a duty to protect the apartment guests, the court, it was a first impression type of situation here, held that the apartment owner did have some duties. So the moral of the story for these older cases is that the third-party contractor performs an act, it must do so reasonably. If a third party does fail to act, despite the contractor's duty to do so, it will not establish liability. However, unreasonable actions, regardless of the contractual language, will impose liability on the third-party contractor. Open and obvious defense. This has been decided since 2005. There's been nothing that has come out since then. The Ghaffari case states that the Supreme Court held open and obvious doctrine does not apply as it is specifically applicable to a premises possessor. Here's this new case. Came out June 22nd, 2018. It is a Sixth Circuit U.S. Court of Appeals case. The issue involved whether BMI, which is the third-party contractor, owed a duty of care to plaintiff when it did not create a new hazard. Now, looking back at the Hill case stated that there was no duty of care to the plaintiff because no new hazard was created. So that issue is kind of here in this case as well. Let me give you a little background on the facts. The plaintiff was an employee of AK Steel. AK Steel hired the third-party contractor, the defendant BMI Refractory Services, to remove bricks and slag from inside a degasser, which I guess is used to extract gas impurities from molten steel. So the third-party contractor completed its contract when removed the bricks and the slag from inside this degasser. The slag was also supposed to be moved from this alloy chute. So it did its job and then they left. The plaintiff was then, the employee of AK Steel, then went into the degasser and was supposed to re-brick it. So while plaintiff was in there, a 40-pound piece of slag from the alloy chute fell and injured him. Plaintiff sued BMI Refractory, alleging that they owed a duty of care to him, stating that they didn't remove all the slag. The court took a look at the case and said that it was the failure to fulfill the contract and not the creation of a new hazard that resulted in the breach of the duty of care to plaintiff. Specifically, the court said, when BMI performed its contract, especially when it inspected the alloy chute for any loose slag, it assumed to act. It thereby took on a duty to perform the act in a non-negligent manner. Viewing the facts in the light most favorable to the plaintiff, Michigan law would recognize that BMI owed plaintiff a duty separate and distinct from its contractual obligations to AK Steel. So, as stated in my next slide, however, the question became whether that duty of care extended to the third party who is not a party to the contract. The Sixth Circuit held that the duty of care did extend to plaintiff because BMI's duty of care to a third party was separate and distinct from the contract. And I state this language down here that further Michigan law incorporates the voluntary assumption of duty doctrine, which states that if one assumes to act and does so negligently, then liability exists as to a third party for failure to exercise care and skill in the performance itself, which is that language I read earlier in the Loki case. So they cite to Loki and Foltz within this case. Briefly before I end here, the court goes on to state that while duty can be created by creating a new hazard, we also have to remember that duty can also be created using the separate and distinct analysis. Going back to the Hill case only looked at whether a new hazard was created. They didn't do the analysis of the separate and distinct. So that's kind of an interesting concept there, that the court kind of forgot about the separate and distinct analysis for some time. And the new case, Leon here, kind of brought it back that there's two avenues to create a duty under the third-party contractor. So that's my webinar for today with respect to third-party contractors. On the last slide is my contact information. Again, I'm at the Grand Rapids office. Please feel free to contact me at any time with any questions. Thank you very much.